The defense of consent in criminal law may operate to render the action lawful as opposed to unlawful. For example, the offense of battery requires the application of unlawful physical force. Where the person consents to being touched, the application of force is lawful. The defense of consent does not apply to all crimes. It can never be used for murder according to DPP v. Pretty. In relation to theft, the courts have held that an appropriation may take place notwithstanding the consent of the owner of the property. See Lawrence vs. MPC and DPP v. Gomez. However, the issue of consent may demonstrate that the defendant is not dishonest. In some crimes, consent will absolve the defendant of criminal liability. For example, rape, assault and battery. In other crimes such as ABH, GBH and wounding, a restrictive approach is taken. Consent may be express or implied. Express consent is where the victim by their words or action indicate that they consent. Implied consent is where consent has not been communicated, but the situation or circumstances may give rise to the court deciding that the victim should be taken to have consented. In Collins v. Wilcock, Lord Justice Goff stated that implied consent existed where there was jostling in crowded places, handshakes and backslapping, provided no more force was used than is reasonably necessary in the circumstances. In Donnelly v. Jackman, it was held that there was implied consent when tapping on a person's shoulder to gain attention. Touching in assisting an intoxicated person may depend on the context. In Marland vs. DPP, there was no implied consent where the defendant grabbed his drunk girlfriend and led her towards his car against her will. He claimed he was trying to keep her safe. Whereas in McMillan v. CPS 2008, there was implied consent where a policeman grabbed a drunken woman to steady her and prevent her falling on some steps. Horseplay covers rough, boisterous play and practical jokes. Consent may be implied in such circumstances. This was seen in R.V. Jones, 1987, where the defendants threw a younger boy in the air with the intention of catching him. Unfortunately, they dropped him, causing serious injury. It was held that consent to rough and undisciplined horseplay is a defense, and even if there was no actual consent, if the appellants had a genuine belief in consent, they should be allowed the defense. There was no requirement that the belief be reasonably held, provided it was genuine. In summary, consent can operate to make an action lawful. It may provide a defense in some crimes including assault and battery, rape and criminal damage. It is not available for murder. It is not generally available for ABH, GBH and wounding unless it comes within one of the recognized exceptions. Consent may be express or implied. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.